Appeal in and for the 5th District of the State of Florida is now in session. The Honorable Bruce W. Jacobus, Judge, presiding. All persons having business before the court, draw near, give attention, and you will be heard. May God save the United States of America, the state of Florida, and this honorable court. Please be seated.
All right, good morning. Welcome to an oral argument session of the 5th District Court of Appeal. I think we have all civil cases today, so each side will get 20 minutes. If you want to reserve time, tell me, and I'll try to get it on the clock here for you. Our panel today is Judge Evander, who's filling in, aren't you? Yeah. And to my left is Judge George Maxwell. Judge Maxwell is a circuit judge in the 18th Circuit, and he's an associate judge for us today. So if you got your cell phones and stuff, make sure they're off. Better make sure mine's off. I don't have it, so I'm good. So they don't go off. Let me get this thing set right.
Are we going to socialize? Are we going to go to the attorney's lounge? We're going to do the attorney's lounge.
Yeah. We're going to take the first two cases, then we're going to take a break, and we'll meet you all in the lounge, the attorneys, and then Judge Berger is going to fill in for Judge Evander for the last two cases. They're filling in for Judge Torpy, who's a little bit under the weather today. So the first case we have is MAZZANET-FIGUEROA versus Scorpion Sports, Inc. Ready to go on that one?
Yes, Your Honor.
Do you want to reserve time?
Yes, I'd like to reserve 5 minutes of my time,
It'll
please.
turn yellow when you get to the, I'll kind of give you a heads up, but the whole thing will turn yellow, so.
Yes, sir.
All right, ready.
May it please the court. My name is Tom Player. I'm an attorney with Weiss Legal Group in Maitland, Florida. I have the honor of representing the appellant, Ms. MAZZANET-FIGUEROA, in this appeal from her trial court claims arising from the tragic death of her husband, Miguel Cruz, in a motorcycle accident. Let me be clear at the outset that this appeal is in no way a reflection on the character and competency of Judge Rodriguez, whom I hold in high regard. I think he did a commendable job in a very complex case in the trial court, but it is a very necessary appeal to ensure that justice is ultimately done. Judges are human, the errors are human, and that's why we have appellate courts. The appellant has asserted 5 points of error on appeal, and because of the limited time, I'm going to address those points that I feel most warrant additional discussion outside of the brief 218 and on Scorpion Sports' legal status under the Federal Safety Act as a manufacturer. The trial court abused its discretion and committed reversible error by failing to instruct the jury on those critical points of law. The trial court took judicial notice of these legal standards, but declined to publish the same to the jury, which I think was an appropriate decision, but indicated that they should instead be presented as a jury instruction. However, in spite of the court having taken judicial notice and in spite of defendant's own admission that the law was applicable and a clear legal concept as stated in their answer brief, at the charge conference, the defendant invited error by at that time opposing the requested jury instructions. The trial court denied the jury instructions in spite of both instructions being correct statements of the law.
And the jury instruction was the one that told the jury that Scorpion was a manufacturer as far as the law was concerned?
There were two requested jury instructions. One set forth the requirements under the Federal Motor Vehicle Safety Standard 218, and the other was the critical one, I believe, that defined the importer as a manufacturer legally.
Even though they weren't actually a manufacturer.
Correct.
In other words, the law says they are.
Correct. The Safety Act says that they are deemed.
You can't import something and say, look, I didn't build it.
Yes, they're deemed a manufacturer, and that is to avoid.
Didn't the jury instruction call them a manufacturer? I mean, the jury instruction, the instructions as the judge gave, called them a manufacturer, didn't it?
Well, throughout the trial and in the jury instructions and on the verdict form, the court interchangeably used the terms supplier, importer, and manufacturer, and sometimes supplier/manufacturer. And I think in light of that, in reference to Scorpion.
What did the verdict form say? Did it call them manufacturer?
They did at times, but that coupled with discussion of counsel during the trial.
You wanted an instruction, something like, as a matter of law, the court instructs you that Scorpion is a manufacturer.
Yes, in the absence of any instruction that clearly and unequivocally stated that Scorpion is deemed by law to be the manufacturer, as admitted by the
The
appellee.
first issue the jury was instructed on was whether Scorpion, the EXO-400 motorcycle helmet supplied by Scorpion Sports was defective,
Yes,
and if so, whether such defect was a legal cause of death.
yes.
So, given that instruction, it doesn't matter whether it's manufacturer or supplier. I mean, to the jury's point of view, the judge is in essence saying it doesn't matter. The question is whether this helmet, which was supplied by Scorpion Sports, was defective. So why is it, given that instruction, as far as the strict liability count, why does it matter if the jury was instructed they were the manufacturer or the supplier, or that they were both the same for legal purposes, et cetera?
I don't think that's clear from that instruction in the context of the multiple references of manufacturer, supplier, importer. In opening argument, opposing counsel made the distinction between manufacturer, which is Kaido, and the...
The jury answered that question, no, correct?
Yes,
Okay.
such that...
Let's think, so if he had said, you know, instead, let's, for argument's sake, he said, look, they're a manufacturer, and this said they manufactured, you know, was the question really is, was the helmet defective? You know, and they said no.
That's the ultimate question, but whether there was...
It would have made a difference if he had said, well, they are manufacturers as a matter of law, or a supplier of the helmet. That instruction says they supplied the helmet to him. Was it defective? And the answer was no.
Yes, but the specific question, I believe... Let me grab my exhibit. The question was phrased in a way that I believe a jury could have made a distinction between, did Scorpion present this defective helmet, or as opposed to the manufacturer, where the jury could be confused about where the liability actually lay.
You know, what I want to say, because the other side of the instruction was, if the greater weight of the evidence does not support the strict liability claim of the estate of Cruz against Scorpion, comma, the manufacturer, then your verdict on that claim should be for Scorpion.
Yes.
I mean, he called him, he said it was supplied by them and is manufactured by them in that instruction.
Well, it's the supplier / manufacturer. I think a juror could look at that and say, okay, well, they were the supplier, not the manufacturer. It's not them.
The question really is, was the helmet defective? You know, that was the question for the jury to decide.
The ultimate question was whether the helmet was defective, and but where liability for that defect lay, I think, was subject to confusion by the jury.
The jury request instruction was to tell the jury that in this case, the manufacturer and the supplier are one and the same and have the same liability.
Yes.
But in the instruction about the issues for your determination, the judge calls them both the supplier and the manufacturer, doesn't make it a fact issue, and says, so the question is whether the helmet was defective. So, I mean, in essence, the judge told them, you know, Scorpion's the supplier / manufacturer. They're responsible for the helmet. Was it defective? I mean, in essence, the judge told them that. So I'm having a hard time, you know, understanding your argument why your proposed instruction would have made it any clearer.
I think it was necessary in the context of throughout the trial, they had heard this distinction between supplier and manufacturer, and without that clear instruction, it allowed the defense to basically, you know, make an argument that it's not Scorpion, it's Kaido. And, you know, the jury...
It was either Kaido or Scorpion that made a defective helmet, was your argument. I mean, in other words, the defect was the issue. Was it defective, right? The others have liability. There had to be something wrong with it. And what you're saying is, well, the supplier said, look, we didn't build this thing. It was, some guys in China or wherever the heck it is. But, the point of it is, at the end of the day, the question, or the jury question was the helmet defective, regardless of who built it or supplied it? And the judge told them that Scorpion did both, but they said no. Isn't that the end of the day? I mean, it doesn't matter at that point. In other words, they said the helmet's not defective. Actually.
I understand, yes, I understand that aspect, but I believe that,
You think if the judge had said Scorpion's a manufacturer, then they would have said, well, the helmet's defective? You see what I'm saying? mean,
yes, I
that's
do see
kinda
what you're saying.
arguing.
I do see your
Had they
point.
known, if the judge instructed them, the Scorpion manufacturer, they would have found it was defective. Well, that doesn't exactly make sense.
Yes, sir.
Considering the time, I'm interested in your other points.
Yes, thank you, Your Honor. As to the warranty claims, this is perplexing. The defendant asserted that the plaintiff's warranty claims, which were added by amendment more than 2 years after the death of Mr. Cruz, did not relate back to the original filing and were therefore barred by the 2-year statute of limitations for wrongful death. Now, this troubles me because the defendant had previously brought these two arguments before the court on a motion to dismiss and on a motion for summary judgment, where the trial court had denied those motions, finding that it did relate back. And then during the trial, without any change in the facts of the law, the court inexplicably changed its prior ruling.
Well, let me ask you this. Assuming you're correct that it either relates back or the statute of limitations did not run, on the express warranty, what was the remedy for a defective product?
On the express warranty,
I think it was kind of like those termite bonds.
it's something to that
They give you
effect.
your money back.
Yes, on the express warranty. Yes, that's correct.
Okay, we'll give you your money back.
And your argument, I think you make some good points on statute of limitations, the relating back argument. But if the jury, if we were to accept the jury found the helmet was not defective, does your warranty claims fail as well? Or is your warranty claim, your argument only good if you prevail on one of the other issues in this case? One of the other issues you raised on appeal? Now, in other words, if you win on one of the other issues, and we say, Judge, you were wrong to dismiss the warranty counts.
Yes.
But if we affirm on all the other issues, does your warranty argument fail as well? Because that means the jury finding of no defect or...
The warranty claims, yes, as to the warranty claims, not as to the fraud and fiducia claims, which is the next point I want to discuss.
Okay. All right.
But yes, but their argument in their answer brief presupposes that we fail on all the other points on appeal.
Okay.
So, but yes, as you pointed out, they can't have their cake and eat it too. Either it is a completely separate claim that does not relate back, and it's subject to a different statute of limitations, which would be 4 years or 5 years, depending on which claim you're talking about, and therefore was within the statute of limitations, or it arises from the same conduct, transaction, and occurrence, and it relates back. And so with respect to that, I don't understand how they prevail on that argument at all. And I think it was clear for the court to
Right.
to
Well, you said if the other arguments fail, you lose on the warranty, but that's not the case for the unfair
Yes.
deceptive trade practices act. So tell me why that would be the case.
As you know, the defendants moved for summary judgment as to the fraud and fraud-related claims and fiducia. Fiducia has to be considered separately because different standard applies. Now, the basis for defendant's motion on those was that Scorpion had met all the requirements to put the DOT stickers on their helmet. Now, the plaintiff argued that this wasn't true with respect to the subject helmet because there was no evidence of any compliant testing at the time it was manufactured. The plaintiff also argued the sworn testimony admissions of Scorpion's corporate rep, Eric Anderson, as well as the facts developed during discovery, created material issues of fact on all of the fraud-based and FDUPTA claims. Now, with respect to the fraud claim, the record shows that Ms. Cruz, it was clear that Mr. Cruz himself saw and relied upon the DOT sticker in making his decision to buy the helmet. Mrs. Cruz's testimony, the substance of which was also presented to the court at the summary judgment hearing, I think itself warrants reversal on that. Now, with respect to the fraud and FDUPTA claims, the appellee hasn't presented any evidence that the subject helmet had been properly DOT tested and certified as compliant before it was placed into the stream of commerce, and in spite of the helmet bearing the DOT sticker. Plaintiff, on the other hand, established that Cruz relied on that DOT sticker in his decision to purchase the helmet. Now, the FDUPTA claim is a separate and distinct claim and should have been allowed to be presented to the jury. Appellee, in its answer brief, makes the erroneous assertion that because the jury found for Scorpion on the strict liability and negligence claims, that the fraud and FDUPTA claims must fail too, as we previously discussed. Appellant doesn't seek to recover damages for the wrongful death of Cruz under FDUPTA. The plaintiff's independent FDUPTA claim is to recover the actual damages, which would be the cost of the helmet and attorney's fees and costs as allowed by the statute. It's possible that on retrial, even if a jury again found for the defendant on the strict liability and negligence claims, that they could nonetheless find for the plaintiff on the FDUPTA claim. So on the basis of summary
The
judgment...
damages under the Unfair Trade Practices Act is the cost of the helmet plus attorney's fees?
Attorney's fees and costs, yes. Now, on the basis of summary judgment having been erroneously granted, I think that warrants a new trial. Now, the other issue, there's a procedural issue too, that they raised for the first time at the summary judgment hearing, an argument that wasn't presented in their motion, and that's set forth in our brief that the arguments, they're constrained by the arguments that were in the motion. And
You hit the 5-minute mark, just so you see that.
yes, sir. Okay, I'll reserve the rest of my time.
Okay,
Thank you.
okay.
Good morning, Your Honors. My name is John Bussey, along with Susan Sewell. We represent the two defendants that were named in this case. Of course, we're the appellee here, Scorpion Sports as well as JP Cycles. The focus of the questions that first came out dealt with the issue of, was there anything improper about the two jury instructions that the plaintiffs requested? The record on appeal, of course, reflects and contains the dialogue and the transactions that occurred at the charge conference. And what they are complaining about, I think you have particularly seized on. Not only were we called the manufacturer, Scorpion, or we called the supplier, and the jury instructions that you referred to, the jury verdict itself correctly stated the model jury instruction that's to be used in product liability, strict liability cases. So I don't think there's any issue, but that to then say we should have been told, or we should have been able to tell the jury that you're the manufacturer. We never ran from that. The questions that are in the record demonstrate that Mr. Anderson, in fact, called himself the manufacturer because he explained the relationship and the partnership between Keto and Scorpion. So there is no question that this jury was properly informed as to the nature of the law that was required for the plaintiff to move forward against us, either on a theory of negligence or on a theory of strict liability and tort. And of course, they really got two bites at the apple, because any entity, the retailer, as well as a distributor, as well as a manufacturer, is in the chain of commerce, and therefore can be liable if a defect is proved. And that was the meat. The jury instructions covered it. The trying to dovetail what was said in the opening without objection, where it was merely an explanation of the relationship of the parties, and then drag that back in 10 days later to say in some fashion the jury has been misled. Now, had I, in closing argument, tried to argue or suggest that we had no responsibility because we were merely a distributor you know what would have happened. One, I wouldn't do it, didn't do it, and I would have been called on it, and there would have been a curative instruction. So the other key element on the jury instruction issue, the second one was merely a preamble, the purpose of the Federal Motor Vehicle Safety Act. And that adds nothing to the issues. In fact, it confuses and would be prejudicial to us because it's basically saying what the public policy is. It's not like a traffic ordinance that gives a jury guidance if it has in fact been violated. So we say that there was no problem whatsoever in connection with the jury instructions. I certainly don't want to take more time or even my time that's necessary with the multiple issues that are raised. I think our brief addresses those, including this argument of relation back. And there's no case that he has cited that says a express warranty claim or a breach of warranty claim or a fraud claim or a misrepresentation claim is not a new cause of action. He made a procedural decision.
What's the statute of limitations on the express warranty?
It would be 3 years, at least under the disclaimer that's there, Your Honor. And remember that what occurred is he's got a
I don't think the wrongful death statute cuts it.
Well, the wrongful death statute should control. So for the warranty counts, it's my position that the wrongful death controls. FDUPTA is not a BI or wrongful death statute, so I misspoke. That would have a different application, but you still have to have a wrong. He says we're arguing there has to be a defect or something defective about the helmet. For there to be an actionable fraud or an actionable FDUPTA claim, there still has to be something wrong with the helmet or the product. And that's why the judge granted the summary judgment. To argue or to suggest that because I opposed the amendment some 2 years plus after, and the judge permitted it over my objection, to then suggest that when I moved to dismiss it and the judge denied my motion to dismiss, then to suggest that at the stage of summary judgment, at least on the warranty count, that in some fashion the judge has made prior rulings is really nonsense. There's a different standard, it's a different time element, and in fact, when you read the record, you will see that Judge Rodriguez in reality understood that what was trying to be injected in this case through the witness cam and the publication of his testimony and his so-called take on the Federal Motor Vehicle Safety Act and trying to inject this issue of the DOT sticker was really overreaching. Now, let's talk about the DOT sticker and the contention that we raised something different in our summary judgment than was in our written papers. In fact, the record is very clear. Our brief points it out, but the record is also very clear that what occurred is we said that what he's alleged, and the appendix to this case has the second amended complaint, and we take the position that what's alleged in the counts on fraud and FDUPTA, as well as these warranty counts, is really a type of what I call sales or puffing. Pure and simple. We have a great factory. We have a factory that has X number of square feet. They used a caricature called an avatar that they called and named Nikki Sloan. Now, come on. Is that something that someone really is misled on? We raised our summary judgment. They, in their responsive paper, said, whoops, we're shifting gears. Though we didn't allege it in the complaint, we're saying the fraud was putting the DOT sticker on the helmet. In truth and in fact, there is no basis of evidence to conclude that anything was improper because this helmet was in fact tested to DOT and to Snell. So they had nothing and they grabbed this one issue saying, well, Mr. Cruz wanted a safe helmet and he understood that DOT meant it at least passed some governmental standard. The gap that they had totally is they had nothing to suggest. They couldn't identify a seller. They couldn't say, excuse me.
What was said to him, I mean, yeah.
Yeah.
I mean, I read what.
Yeah, so this case was a hotly contested case. This jury, in fact, had the ability to conclude that he wasn't even wearing our helmet.
That was your theory of the case, wasn't it?
I'm sorry?
That was your theory of the case?
Well, our theory of the case
Your
was...
expert said it was on the handlebar of the bike.
Yeah, for it to have the type of damage that it had, that it couldn't have been on a head because the crushing was sustained by significant forces in the 6, 7, 800, 900 pound. And that's also significant on the theory of a, quote, bad or defective bracket. Their theory is that the helmet's on, he's sliding on the road, and therefore, without any other thing other than just basically saying, I'm a helmet person, as a couple of their people wanted to say, it broke at 12 pounds. We metallurgically tested this. We proved to this jury and gave them a choice of an expert witness who said their test was done improperly. Their test, as put in the test device, is calculated and will in fact come out understating the strength. So our whole premise is he didn't have this helmet on, and there was factual witnesses. Yes, he had a lot of friends that said, I always put on the helmet. My brother pulls it tight. I always pull it tight. I see my husband pull it tight. But even in her testimony, there was questions about what color was the helmet. There was questions about where was it, when was it purchased, the use of the helmet. So all of those issues were in a hotly contested case that was fairly and fully tried before a jury, and in fact resulted in an outcome that clearly we were knowledgeable enough to know that we're not going to get a summary judgment on a warranty count, on a strict liability count or a negligence count, but we had a very strong scientific case. And they can have witnesses that want to say, I saw this or I saw that. But our case was a scientific case. All of the points that they've raised, I don't know if in his rebuttal he'll discuss the juror misconduct. He labels the juror misconduct about a tax.
He didn't mention it.
Yeah, so maybe I ought not to say anything, and then he can't rebut it, right? Thank you, Your Honor.
All right.
Thank you, Your Honor. Yes, because of the tight time, I have had to leave some issues to stand on the briefs,
Right.
obviously. Back to the argument about the jury instructions and the negligence and the overall theme of this case, which, and these cases like these nationwide, which turns on jury nullification. In this case, the unrefuted testimony of the expert witnesses, including defendants' experts, David Tom and Kevin Breen, established that in this particular instance, if the helmet was on Cruz's head when the collision occurred and subsequently came off, then the helmet was not compliant with FMSVV 218. Now, the defense confuses this issue and obfuscates by talking about compliance with 218 in reference to exemplars of the helmet, but there is nothing to show and nothing but unrefuted testimony that if this particular helmet was on his head, which was a disputed fact at the time the collision occurred, and came off, then it was not compliant with 218. The plaintiff has a right to have the jury instructed on the law that applies, and as this court said in their opinion in Four Line Security versus Scott, trial court commits reversible error when it refuses to give a requested jury instruction which accurately states the law if there's evidence supporting the instruction was necessary to allow the jury to properly resolve the issues in this case. In this case, I think it was critical for them to clearly understand the applicable law and the definition of manufacturer. Litigants have a right to have the court instructed on the jury on the law applicable to the evidence under the issues presented. Interestingly, the same principle was recently, last month, reiterated by the first DCA in R.J. Reynolds Tobacco versus Jewett. There's a motion for rehearing in that case, but I cite it here for some dicta which very astutely noted that the trial judge's reference, I'm quoting, to give a non-standard jury instruction is reflective of a cautious approach that most trial judges exhibit. This predisposition against non-standard instructions is understandable Judges are human, none likes to be reversed. But the Jewett Court went on to say that is applicable in this case. Trial judges should not cast aside their natural cautionary approach, but they may need to step out of their comfort zones from time to time where legally accurate, factually relevant, non-standard instructions are proposed to supplement the standard instructions in a way that enhances the jury's understanding of the law. I think it was error for the judge to not instruct in this case. Opposing counsel said in his argument that they embraced being a manufacturer in this trial. If that's the case, then it begs the question of why they opposed the jury instruction. And the reason is pretty clear if you look at the entire record, that they opposed it because it allowed them to make the empty chair argument that it's not us, it's them, it's the manufacturer. So I think that, in conjunction with all the other points that have been raised on appeal in the briefs, warrant reversal and remand for a new trial. Thank you.
Thank you.